Meeting of August 8th, 2019, Scott County Planning Commission. Under Commission business, we've got the approval of the July invoices. I'll need a motion.
I make motion.
Motion by Mrs. Mizell.
Second.
Second by Mr. Stone. All in favor say aye.
Aye.
Anybody opposed? Passed. B, approval of the July 11th, 2019 minutes. Take a look. And
So moved.
okay, was that Mr. Stone?
No.
Moran. Mr. Moran, sorry, Byron. Got a motion by Mr. Moran,
Second.
second by Mr. Wiseman. All in favor, say aye.
Aye.
Opposed? Passes. Next on the agenda is the approval of the August agenda. Need a motion for the August agenda be approved?
I make motion.
Motion by Mrs. Mizell,
Second.
seconded by Mr. Smith. All in favor, aye.
Aye.
Opposed? Okay. Items for postponement or withdrawal. I know we do have one item for postponement, which would be PDP 2019-31 Hotel Development, Icabana Path Preliminary Development Plan for a 93-room hotel on 1.8 acres located southeast of Blossom Park Drive and Icabana Drive. That will be postponed. So if you're here either for it or in favor of it or against it, I should say, that will be postponed, meaning till next month's meeting. Okay. Anything else, Joe, that's postponed or withdrawn?
No, that's it.
Okay. So again, if you're here against or for the hotel, that will be heard next month. Item number E, consent agenda. We do have one that's consent eligible. Actually, yes, just one. FSP 2019-32 Duncan Property. It's a final subdivision plat to subdivide a 5-acre lot from parent tract of 161.6 acres located at 1279 Burton Pike, Kentucky Route 620. Is anybody here to hear this in favor or against? So, okay. So we do have some people who want to hear that, so we'll hear that tonight. So we won't vote on that. So, okay. So next thing, we'll go right into old business. FSP 2019-17 Jones Property, final subdivision plat to divide one tract into four tracts, creating a 6.14 acre tract, 5.88 acre tract, 5.04 acre tract, and a 5.16 acre remaining tract located at Willowbrook Lane. Ms. McCallum?
Yep. All right. I know you guys have heard me go through this before, but I'll just go through it again quickly for you. It is a final subdivision plat to divide one tract into 4 tracts. It's zoned A1 agricultural, although surrounding properties are also zoned A1. The subject property is approximately 22 acres in size. Oops. Sorry. So this is the subject property here. This is the site. I know this isn't a great aerial. Cane Run Road is down here. Craig Lane's up here. And this is Willowbrook Lane, which is what provides access to the subject property. Okay, just a brief history of the project site and the Willowbrook Cluster Subdivision. This is a master plan and preliminary subdivision plat that was approved by the Planning Commission in 2001. This was never recorded or became a final subdivision plat. This was essentially just a concept plan for what Willowbrook could have been. I highlighted essentially where the subject property is. As you can see, it was earmarked for future cluster subdivision development. Okay. This is actual phase 1 of Willowbrook Subdivision that was approved by the Planning Commission also, I believe, in 2001. So you can see the 20 cluster lots that are existing today. You can see where the subject property is. Back here, that was earmarked for future development. And this is where the preserved acreage is. So Willowbrook Phase 1, essentially all together, was 100 acres. 25 acres were used up for the cluster lots, and it was earmarked with 20 dwelling credits. And then this is the preserved area. At this time, it has no dwelling credits. And then this is the future development where the subject property was. It was intended to be future cluster lots, but that never came to fruition. Alright, this is the plat that created the 25-acre tract. It essentially lost a few acres, which I'll get into after, but I did just want to point out this is where Willowbrook Lane is. It's a county-maintained road, and this plat is what gave existing access to tract 2 here, which again is the subject property that we're looking at. And again, I wanted to point out this is where the preserved area is where the existing cluster lots are for phase 1, and then this is the subject property. Right. And then this is the transfer and consolidation plat that essentially brought it down to the 22.4 acres that you see today. So just so you know how it got to that size, there's not much to add with that. And then this is the proposal that the applicant has brought forth for the commission to hear today. Like I said, they're essentially proposing 4 approximately 5-acre tracts here. They are showing that they'll meet all of our setback regulations and minimum lot width at the building line. Again, here's Willowbrook Lane. It's county maintained. The pavement ends approximately right here. So the applicant, due to the 4 lots, would be required to extend Willowbrook Lane and create that turnaround. They would have to meet county road standards, so you would be looking at a 20-foot paved roadway with a 45-foot paved turnaround with a 55-foot right-of-way. So that's essentially what we're looking at. The applicant with this subdivision plat is proposing to meet all of our required regulations at this time. With the 22 acres, you are looking at 4 dwelling credits being available on this lot, which is what she's showing here with 4 lots. And I did just want to point out this isn't an erroneous line. It was intended for a measurement and shouldn't be in there. I didn't want that to confuse anyone. So, all right. With that, staff is recommending approval of the application. Only 2 standards or conditions that staff placed on it that are slightly different from the norm is about the roadway that will need to be constructed prior to final subdivision plat approval, and there were some requirements for GNW sets that will have to be met. Are there any questions for me?
Before we ask questions, for the record, Commissioner Mifflin is absent and Commissioner Caldwell is absent. And then Charlie, would you swear everybody in, include Miss Michaela?
Yes,
Do I have to swear?
Everyone signed in to speak tonight. If you could stand, raise your right hand, please.
I think it's supposed to.
Do you swear or affirm the statement you're to make tonight to be the truth to the best of your information and belief? Thank you all.
Thank you, Charlie. Any questions for Michaela? Okay. Thanks, Miss Michaela.
Yep. I'll just
The applicant like to speak?
I can speak, or I can wait till other parties have
Okay.
spoken, and I can answer any questions.
Let's do that. Anybody here to speak in favor of or against the FSP 2019-17 property? Please come up to the lectern and state your name and address for the record.
Steps and me don't get along so well together, so Heather's kind enough to hand out the packet of information.
Thank you. Thank you.
John Sharp met with the Homeowners Association twice.
State your name for the
I'm
record. Sorry.
Mike McMurray, and I live at 107 Ashwood Circle, and I'm in the Willowbrook development.
Thank you, sir.
John Sharp met with the Homeowners Association twice, and during both meetings he was adamant that Ms. Jones does not have dwelling development rights attached to that land. He also said that to you in his testimony at the May 9th meeting. And he also said that in the letter that he sent to you, which I think was dated May 6th. So when John died, I tried to figure out what was he saying and what did this mean and where was he coming up with this. And so what I put together is my analysis of what I think John was saying. The first 2 pages basically is a written version of what I'm saying right now. What I'd like to direct you to is the 3rd page, which is labeled document number 1. What I've done here, this is the Sharp Farm Parent Tract number 1. And I'm calling it number 1 because there's 2 farms involved in this. What I've done is outlined the original farm. And off of that farm, over time, tracts have been sold off. And you can see in the bottom left, there's tract number 1, which is 5 acres. Bottom right, there's tract number 2, which is 5 acres. And then kind of in the middle of those two, it's tract 3, and this says 31 acres. I think it was finalized at like 25, but that's not relevant for the purposes of my discussion. But tract 3 is what Willowbrook development was built on. And then you can see in the upper corner on the left side under parent tract John and Shawana Sharp's name, it says 110 acres remaining. So when you take the acreage in tract 1 and tract 2 and tract 3 and the 110 remaining, you come up with 151 total acres. And what I've done is I've dotted lined Miss Jones' property so you can see that her 21 acres is clearly part of the original parent tract number 1. So we start out with 151 total acres. Now we know 100 of those 151 were used for Willowbrook, because Willowbrook's got 20 homes. You have to have a total of 5 acres per home. So that's 100 acres. So we know between the land that the homes were built on and the required set-aside reserved space, you have 100 acres. So 100 of the 151 is taken, dedicated, whatever the right word is. Now, John made mention several times where he said, quote, at the time, unquote, the ordinance said that if you had a 25-acre piece of land or more of agricultural land, that you were entitled to a dwelling development right. And he said to you in his testimony and also in his letter that he basically was keeping 50 acres. So that's two 25-acre tracts, each with a dwelling right for each of his 2 sons, in the event the sons wanted to live on a 25-acre tract and have a home built on it. So I think this is where John was saying that all of the development rights in this 151 acres were dedicated. 100 for Willowbrook and the other 50 for the 2 25-acre tracts that he was reserving for his 2 sons. Which is why I think he said there are no more dwelling development rights that can be obtained or assessed against this 151 acres. And when he said to you, you can't just make these up. You can't just give them to her because they're not there. So that's one point. The second thing I'd like you to look at is the next page, which is labeled document number 2. This is part of the plat map that Michaela showed 2001 of a proposed addition to Willowbrook. And what this is a piece of that. I asked her if I could get an 8.5 by 11 blow up of the whole thing, but it's so small you can't even read the numbers of the words, so I chose to do this. What this shows is on the left side on the top, where I've labeled it Jones property, is the proposed future development. And in this case, it was 18 homes that were being talked about at that time. And then below that Jones property is where Willowbrook currently is. Now on this plat map, it shows reserved for open space numbers. And I've put a tag in the lower left. It says 73 acres reserved for open space. So that was on the map for Willowbrook that was charged against the farm number 1. But this also shows that there's another farm involved, and I've labeled that farm number 2. And it shows 2 items up there. It's 62 acres reserved for open space and 30 acres reserved for open space. So when you add all this reserved for open space together, all these 3 numbers, you come up with 165. And I'd like you to look at the next page, which is document number 3. This is from the same map, just a different section. I'd like you to look at the bottom right corner, where it says site statistics. Second line, 255 total acres. Now we know farm number 1 is only 151 acres, so this had to get 102 from someplace else. So 255 total acres is involved in this proposed expansion, And the bottom line of that site statistic says 165 acres reserved for open space. So this tells me that that proposal for that expansion on parent tract number 1 was dependent and needed development rights and reserved open space from another sharp parent tract. And that's what John said. He said that in his verbal testimony to you that any future expansion that was being thought about by Willowbrook would have depended on the use of building rights and reserve space from another parent tract, sharp parent tract. He also says that in his letter on the bottom paragraph. He said that because there are no more development rights on the original 151 acres, any development rights that Ms. Jones can have to be designated by another or from another sharp parent tract. So to me, this supports John's 2 main points. Number 1, there are no more development rights that can be obtained from the original 151 acres. And number 2, if she were to get development rights and required reserve space, it would have to come from another sharp farm, which is farm number 2. Thank you.
Thank you, sir. Anybody else want to speak for or against this application? Please state your name and address, please, for the record.
Hi, my name is Sherry McMurray. Coincidentally, same last name as the guy you just talked to. Or listened to, yeah. Thank you. I also live at 107 Ashwood Circle.
Thank you.
In Willowbrook. Heather's passing out. Thank you, Heather, very much. An outline of my remarks and 3 exhibits, one of which has 3 pages to it, and it's obvious it looks different from the others. I want to first review what I said at the May meeting. All of the members in our homeowners association, of which I'm the vice president, our president, unfortunately, is out of town right now, understood, and we have verified this through HOA meetings, that the agricultural land surrounding us would remain undisturbed. And those of us who live there appreciate and support agriculture land preservation very, very strongly. I have a farm background. Heather has a farm background. There are others in the community. We live in a beautifully developed community which pays a high tax burden to this county to keep it that way. There's at least a $10 million valuation in that community, which pays at least $1 million in taxes per year to Scott County. This proposal requests access through a neighborhood that we maintain. We maintain the green space. No one else. We maintain the road signs, and we maintain the look of the properties. We have seen this proposed plan. It's been called a development over and over. I fail to see what about that can be termed a development. There are no apparent limits on building types or sizes. I believe Ms. Jones in one meeting mentioned she would require 1,800 square feet on building size. She told us on Monday night 1,650. I'm not sure which it is. Maybe it's neither. There's no mention of the required tree lines or fencing changes or fencing maintenance, which in our requirements for the development, we maintain half of. Whether or not her part of that property fence is being maintained is arguable at best. There is no mention of any existing easements here on her lot, which is E4, on lot E4. Contrary to what Michaela said to you, the tract was registered with the county, and I've got a copy of it. That's what I was looking at when I disturbed you all. It was registered in 2003. And those easements exist in that registration. Net, we in Willowbrook have pages and pages of regulations and limits that control our properties, what we do with our property, how our property looks, how it has to be built, what sidings have to be used, etc. There's nothing here that suggests that there's going to be any controls, and at least 6 of our homes are abutted directly, including our house. It just, to me, looks like a bunch of lots pushed together. And I appreciate what's being said about, well, it's 5 acres and you can do what you want with 5 acres, but we beg to differ in this case. Moving to the rest of the outline. If you look at Exhibit A, this is, I'm going to lose this here in a minute. Exhibit A is a piece of a document, which is the Articles of Incorporation of Willowbrook Rural Development HOA Incorporated, that was filed with the Secretary of State 10/29/2001. If you look at the part of it that I blocked in hot pink, you can't miss it. I'll read it. It says, upon the dissolution or final liquidation of the corporation being that built and developed Willowbrook, any remaining assets of the corporation shall be distributed to one or more organizations designated by the Board of Directors at that time to be used in such manner as in the general judgment of the Board, pardon me, I added general, in the judgment of the Board of Directors will best accomplish the general purposes of the corporation. Each of the organizations shall operate to be exempt from the federal tax under Section 501c3, 4, 7 of the IRS Code, etc. The only tax-exempt organization that exists in and around this area is our HOA, which means that the common ground which was left undeveloped belongs to the HOA, which turns into green space, but which also includes something that I'm going to talk about shortly. Attorney Bruce Langford, in fact, told our previous president that the common areas belong to the HOA. That was his opinion. Members of the HOA board met with the county attorney because he was the attorney of record, not because we ran to the county attorney, but he was the attorney of record for the Willowbrook Development Corporation throughout its existence. We discussed several issues with him, but we came to focus on the access to the land in question. If you look at Exhibit B, the first thing you have is a perspective shot where the gentleman who took the picture was standing at the end of Willowbrook Lane, the asphalt. You can see that it is grass and gravel. And you can see in the very, very distance that shiny thing, that is the fence to Ms. Jones' property. You can also make out, if you look very closely, the back fence of Willowbrook Lot 17, which is contiguous with her property. Turning the page, you can see unmarked where Willowbrook Lane ends and it stops. See that little gray? It just stops, and then you got a bunch of blotches. And then if you look carefully, you see the back fence on the property, which is Lot 17 in Willowbrook. That's actually, the address on that is actually Ashwood Circle, contrary to the next page. The next page is just a helpful little pointer for you to show the end of Willowbrook Lane, the property lines the gate to her property, the end of the road, and that last house on Ashwood Circle. Like I said, he's got that mismarked, but nonetheless, the house is,
Their driveway's on Willowbrook.
the house is there. That's correct.
It's vacant.
That's correct. Okay. Thank you. All right. When we met with the county attorney, it was his clearly stated opinion that our issues raised indicate that the county road stops about 100 feet short of the Jones property. He said, in clear terms, the county does not acquire gravel roads. We believe we've already established that that common area belongs to the Housing Owners Association, Homeowners Association. Which means, now, it has been measured, I would say badly, with household tapes. It has been paced off. We know it's at least 100 feet. It could be more. Number 3, the county attorney shows us, that's Exit C, showed us this PVA map. This is from him. And if you look in the sort of upper left-hand corner where I marked 22, that is the acreage in question. And you will note the straight line that it follows right behind the properties on Ashwood Circle. In fact, her own survey submitted to you indicates the road would have to be extended some 165 feet into her 22 acres before building the development road, or the road that is shown on there. We've met with 3 attorneys so far. All 3 have stated that she does not have a right to improve, i.e. build on, properties she does not own, and the county does not own. Since the Willowbrook HOA owns that land not inside her property, we can state categorically that the HOA is not inclined to sell or grant ownership of the approximate 100 feet to Ms. Jones. Attorney Harold Sims was particularly concerned about a third party improving another party's land. In fact, he did not think it to be legal, and he in his long experience in Scott County, could not think of a situation where that was allowed.
Question I have, and I don't mean to cut you off, but don't we either need the attorney here or a signed affidavit? Because to quote, and I noticed I kind of read a little ahead, you've quoted 3 different attorneys, and this is what they've said. But Charlie, can we just say, well, we heard from this attorney, he said this, she said this.
Well,
we don't have a stated affidavit.
Yeah.
I'd hate to, because.
If you wish to have affidavits, we will pursue that.
Okay.
Well, I mean, obviously it's hearsay, but on the other hand, it doesn't comport with what our regulation and practice
Okay.
is, so I'm not really sure that it matters.
'Cause I know in the past we've had people say, well, our neighbor said we don't want this. Well, they're speaking on behalf of a neighbor,
Well,
a person who's not here.
Like I said, if you wish, we will pursue affidavits. I have no concern
I just hate
that we couldn't
yeah.
get those because they're being accurately stated
Or not
here.
hired attorneys is my guess. So you continue, I'm sorry.
County Attorney Marshall studied the PVA and paper plats and determined that no easements in any plat allow her access into that property over that land. Attorney Nathan Billings indicated that this development doesn't address existing easements, the existing tree line preservation easement, or the existing Willowbrook deed restrictions. This caused us to look more carefully at the existing plats, the registered one that I just referred to, only to realize that in addition to Billings issues, there's a 100-foot utility easement and a 20-foot water line easement on the registered plat that cross her proposed lot E4, which would render it not a buildable portion of that because it would be less than 5 acres. Her deed, dated 102212 requires her to be subject to all applicable restrictions, covenants, agreements, and easements of record. Those are easements of record. The HOA is obviously pursuing an attorney in this matter, but we have not yet finalized that due to the time it takes for a full HOA membership and collection of assessed fees from each member. As you all are well aware, we're just coming off shutdown, and folks are out of town having vacations, I guess everybody except us. But nonetheless, it takes some time. So we have not yet finalized an attorney. Finally, we urge this commission to deny this development based on our objections and questions. However, if you choose to approve, we will need to have the courts address these issues. We will have no choice. There are other members who are prepared to comment here. I would reserve the right to speak again as necessary if it occurs. Do you have any questions for me? Yes, sir.
You're using the term green space and common areas. Are you using those two terms synonymously?
Yes and no. The common areas were given to us as the tax-exempt entity from that corporation when it dissolved. Part of it is green space, which we maintain. The other part of it is that 100 feet of non-blacktopped area.
Now, does this include the 100 acres?
No, we don't own the 100 acres.
Okay, this is just within your subdivision.
Yeah, that's correct. The Sharp family owns the rest of that property.
You said the county didn't own the property, nor did the homeowners association.
No, I said the homeowners association did.
Oh, who pays the taxes?
It's tax exempt because it's ours. We're a tax exempt organization.
On all those other properties.
The green space and that 100 feet is tax exempt.
So is that property deeded over to the HOA? Is there a deed in place for that property?
I can't answer that. We're not aware of one. You've seen the document which would establish us as the owners, or the piece of the document.
The PA has it listed as belonging to HOA.
Thank you, Sandy. Sandy's our past president. Any other questions?
Any other questions for Mrs. McMurray? Yeah, thank you.
Thank you, gentlemen and lady.
Anyone else like to speak in, please?
My name is Heather Sapp-Gooden. I am a very proud resident of 100 Willowbrook Lane, and I've built my house with my late husband 12 and a half years ago. And the reason we chose Willowbrook was because we lived in a different community in Scott County when we first got married with 0 restrictions. And while that is fine for some folks, we watched our property value stay very stagnant through that time. And I'm a school teacher. I don't make a lot of money, but we were able to build our house in Willowbrook. And one of the reasons we chose the development was because of the restrictions. And that, because of that, and the restrictions on things like outbuildings, they have to look like our homes. You can't run to Lowe's and buy one. In-ground pools, the fencing that Ms. McMurray referenced. All of those restrictions have allowed my property to continue to increase, helping pay those taxes. So I realize that you are unable to mandate that this property be part of the HOA. Is that correct? Yes. So I feel the only choice then that we have as an HOA is to be against this, because we don't know what we're getting and what will be abutting, $500,000 homes as far as property value goes. So that is my concern, because I have a 6-year-old. I got a long way to go, and I love my home, and I want it to continue to be an investment for my family.
Thank you.
Thanks.
Anyone else want to speak? Please, again, come up and state your name and address.
Good evening. I'm Sandra Dawkins. I live at 104 Ashwood Circle. I am
As Sherry has mentioned, I am also on the board of our homeowner association. We are a small group of 20 homes who take pride in our neighborhood. As I said, we are 20 homes, but we're many more people. Rita Jones and her proposal is one person with a 4-home proposal. It appears with the responses we've gotten from you here at Planning and Zoning that you are acknowledging and listening to the minority and not to the majority. And we live there. None of you all live in Willowbrook Estates. We go over and above to maintain our entry and common area. We even mow extra road frontage to keep the areas clean and welcoming. We follow rules and regulations, like Heather mentioned, which are tied to our deeds, and we have a state-registered HOA. We've had to occupy a lot of time in the last couple months talking to attorneys. In fact, we talked to 5, and I know we don't have affidavits from each of them. We even spent some time talking to Charlie Perkins. We feel like there's a lot of legal issues that we needed information about. This relationship, or lack of relationship with Rita Jones, started long before we even started with planning and zoning. Rita approached us and spoke to more than one homeowner, my husband and myself included, about purchasing the common area. It's about a 2-acre area, around 5 acres that she owned at the front of the neighborhood. She has since sold that 5 acres, but she proposed that we give her that or sell her that 2 acres, thereby making her have a larger than 5-acre lot. She wanted to add the 2 tracts together and further subdivide it, and then add those homes to our Willowbrook neighborhood. She was willing at that time to follow HOA rules and regulations for those lots. But those lots did not even meet your cluster subdivision rules. There was no green space to make each of those lots 5 acres. The lots that those lots would have accessed off of Oak Farm Road, which is one of our HOA roads. Now she proposes that the 22 acres come off of Willowbrook Lane, which is another Willowbrook Estates road. But she doesn't want these lots to follow our HOA rules. She was willing to do that on the other lots, but not on these. We see that as a manipulation to meet her goals as she sees fit without regard to the effect on our neighborhood. In August of 2018, which was actually a year ago, we voted as a HOA against her proposal to purchase that common area. She continued to make phone calls after we told her we were not going to sell that and have that property in our HOA. And she called all the way up through January of this year, January of 2019. She spoke to my husband, who was actually the acting president, not myself, informing her each time that she called that the HOA had voted it down. We felt harassed and threatened by her calls and comments. Needless to say, we've not wanted to approach or negotiate with her after these previous encounters. We've also talked to Chad Wallace, our magistrate, who's been instrumental in discussing neighborhood issues across our district. Issues can and should be addressed before they become a problem. I know that you as planning and zoning can set and encourage regulations and restrictions. You did set regulation restrictions for the neighborhood that was next door to Ward Hall. Our neighborhoods, other neighborhoods that do not have entry into their HOA like Ironworks and Homestead, have issues and things that they have to deal with now because they allowed additions and different things to occur, but yet problems still occurred. We don't want to have these issues. We want these issues addressed now and eliminated instead of them being something long-term that we have to deal with or even take to court. We feel very much like we are the homeowners that are going to be left behind to live with whatever it is you decide to approve on this proposal. We already have an immediate neighbor with a 5-acre tract that borders 8 of our lots, the Binghams. They maintain horses, fences, and barns tastefully. We still have green, open, farm productive, beautiful space through them. We agreed to maintain our side of their fence. We know farms and farm owners are not bad. Our fears and concerns are based on the lack of regulations on these proposed 5-acre lots. It is a fact that the only access to these properties will be through the Willowbrook Estates, and we maintain the entrance and common area. We maintain these areas. Some neighborhoods I know here in Georgetown and Scott County don't even maintain their common areas, but we do. We have pride in taking care of that. We care about our neighborhood. As Sherry mentioned, we have contacted Nathan Billings, who's an attorney who's active in Scott County subdivision regulations. He's recommended that we take care of this before it reaches the point of a court case. If he has to become involved, it will require quite a few $1,000s for our HOA to retain him. So as stated, he recommends we attempt to fix this first. We see some reasonable restrictions regarding the homes, fences, and barns, as we already do with our adjoining farm neighbor. The lot owners of these proposed lots could become part of our HOA. We're not opposed to that. They would be limited partners, but they would be part of our pride. And the tracts could even then be marketed as being members of the HOA. And finally, I'd like to add that we like farms and we like green space. That's why we bought our properties there. We take pride in having privacy, safety, and security in our homes as members of Willowbrook Rural Development HOA. Questions?
Any questions?
Yes, sir.
If these lots had the same housing requirements as your HOA does,
yes,
would you have any objections to this?
No, we would not, but I don't think that that's, we have a restriction on the animals in our HOA, yeah. And I think a 5-acre tract, as our adjoining neighbor, they have horses, you know, and I don't think it would be realistic to limit that totally for a 5-acre tract.
Now, if you get along fine with the 5-acre tract next to you with horses, do they have a home as well?
Yes, and barns.
Does it match your HOA requirements?
No, yes, very closely. I don't know the size of their house, but Jody's here. She could even address some of those comments.
And let me slide up here while Sandy's still up here.
Say, please, for the record, state your name and address.
My name's Jody Bingham, and I'm at 743 Cane Run Road, so I actually come off Cane Run rather than going through the subdivision. But we've been there almost 15 years and have had the opportunity to see this development grow and become the beautiful place that it is, and to meet so many really nice people. And I feel fortunate that we have great relationships with all the neighbors around us, and you know, have really just enjoyed that relationship. Our home is a little different. It was built in 1978, I believe, by the members of the Covington family who originally owned that tract. So it's probably not within, you know, the same kind of caliber as the Willowbrook homes, but we do try to keep things trimmed and painted and nice. And even with the horses, you know, my neighbors will call and say, hey, you know, there's a board down somewhere on a fence, and so, you know, we may all run out and take care of it. You know, there's been plenty of times when we've gotten together as neighbors and said, you know, this is something that we all need to deal with to make sure that the animals are safe and the kids are safe. So it's been a very good relationship, and I can't say enough good things about the people in this community that have kind of grown up around us. And I would just hate to see the values of their property be impacted in any negative way.
How many acres do you have?
5.
Oh, 5. Mm-hmm. Now, I don't understand why, if your 5 acres are fine, why these other 5-acre lots would not also be fine, and why that would reduce your property value so much if hers doesn't.
We don't know what's going to happen on theirs because there's no regulations or restrictions for those 5 acres.
So it's the lack of regulations that you're concerned with.
I mentioned that.
Well, go ahead, Mrs. Mizell.
I could have swore early on in this process, like second or third meeting, that Mrs. Jones agreed to the HOA conformities of the houses.
We'll let her answer that probably in a second for you, but
yeah.
I mean, it would be definitely limited to one house per 5 acres. I mean, you wouldn't have several homes on those.
Right, the style and the concrete and
Yeah.
stuff like that. I could have swore that
We'll let
was
Mrs.
agreed.
Jones answer that here in a second, maybe. All right. Thank you very much. Any other questions?
Yes.
Okay. Thank you. Anybody else want to speak? Please, sirs, come on up.
My name's Michael Dawkins. I live at 104 Ashwood Circle. I just wanted to make a brief comment. I've been listening to all this. I think I've been at all of these planning and zoning meetings, except in June. We're on vacation. Mr. Silsky, with all respect to you, you're questioning possibly some testimony you're hearing here.
Well, just a lot of times we have people come in front of us and say, people say
I know what
things.
you're saying. We're repeating everything these attorneys are saying,
Right.
but it kind of puts the onus on us to prove something that I think is obviously shouldn't need to be proved, that we own what we own. It's in the plat. It's on the plat. It's part of the original parent tract. Now, we're arguing a point, I guess, to kind of hope that this all resolves in a very positive manner. We're not trying to stop anything per se.
Right.
We know we can't deny access, but, we have rights, and we're having to prove our rights. You're beating us to death with these meetings. I mean, I know that's what, you always have opposition
Right.
to things, but why do we have to prove something that we think is an obvious?
I think just what I meant by the comment was
Yeah.
is to say this attorney said this or this attorney said
No.
that,
Yeah.
and it's not a signed
And
statement or affidavit by that attorney. It's hearsay,
Yeah.
and we've had a lot of people say, well, my 10 neighbors don't want this, but they can't be here tonight. They haven't
I
signed
understand
anything.
that, but
So I guess
my
that's
point-
my point.
My point kind of shifted to, we have to prove, our point about what is legally ours or not, and what
hopefully
can
we'll
happen,
resolve that
and
for
what
you.
can happen to that 100 feet in limbo kind of thing. Do we have to prove that? We have to hire an attorney. We have to collect HOA fees. Is that for us to do to convince this planning and zoning board
Not
that there's
necessarily. We'll
there's some
discuss it as
issues
much as
that-
we can,
that
and if
need
we can
resolved?
resolve it
I
tonight,
mean,
we will, and if
yeah.
not, we'll continue if we have to.
If I could just answer that one, Mr.
Sure,
Chairman. There's no
please.
requirement that you prove anything. The public records are going to dictate what the applicant can and cannot do. You have plats. She's proposing one. They've got, the plats that are already of record, they dictate. If there's a right-of-way on one to get to the next property, then the next one can come in and complete the road to get to the property. That's what I believe they can do on this one. As far
Well, there's a
as
right of way for access. Correct me if I'm wrong.
well, yes.
Yeah.
When the county
Okay.
when the county accepted it and the final plat was approved, it shows the right of way to the edge of the property.
Okay.
As Rand said, and correctly, of course, the county's not accepting the road the part that's not built. They don't accept grass or gravel. They've accepted only what's been built for the current use of the current residents. But the right-of-way is there to the next property. The next applicant can build to the next property and on into their development.
Well, not to
and-
belabor this, but we're not arguing that point about access. It's those other issues, and I don't want to drag this on.
Well,
I understand.
but basically the existing plats answer all these questions, and no, sir, you don't need to prove anything. It's not part of your development, therefore we can't make them join your HOA. We would, I dare say, if we took a poll, we'd prefer that they did, because I think that would make for better relationships between everybody. But we can't require that, and we can only require what we have the authority to require. If this was all part of one development, this was phase 2 of that same development like it was originally planned, absolutely. But it's not. Phase 2 never happened. That proposed for future development never happened. It ultimately went back to the bank. It was sold to a third party, in this case, Ms. Jones. We can't go back and require her now to go back and meet something proposed for your phase 2 when there was never a phase 2.
Okay.
That's simply something we can't do, even though much of it, again, I dare say we would agree with. We would say that is better.
Well, I think we understand what you're saying. There's some specific points that I really didn't come up to address other than, anyway, I'm just at a loss for words. I think Sherry's made some good points. I think we've all made some good points. And I think there's a lot of questions to be answered. That seems like we have to answer most of these questions or present a certain amount of testimony or whatever that. Anyway, thank you for hearing me out.
Thank you, sir.
Thank you.
Anybody else would like to come up and speak? Miss Jones, would you like to come up and speak?
What about Mr. Sharp?
Oh, did somebody else? I didn't see anybody. Does this gentleman want to speak?
Mr. Sharp.
Go ahead. If you don't mind, Miss Jones, let Mr. Sharp speak. And
Beckham Sharp. I'm the owner of the adjoining properties. I just want to thank you guys for giving me a chance last month to kind of go in depth and look at this a little bit. Other than what the remarks of the HOA is, I haven't really further made any actual findings of anything set on paper and in stone of what my dad was trying to say, other than what Mr. McMurray has said. So I don't really have anything further to add to that. If I need to come back up here and answer any questions, though, I can. Thanks.
sorry for your loss.
Thank you.
Miss Jones.
I don't know where to start. Mr. McMurray, is that McMurray? In looking at what he proposed, I saw several errors on that plat. I see that the veterinary who owns out front, what's his name? Weekly. Dr. Weekly's property is not identified. And if there's 51 acres left, then there surely would be plenty of development rights left that would include my property. The HOA does own green space out there. It surrounded a 5-acre tract that I owned. I did approach them to try to purchase that, see if we could possibly make that into a cluster development. They didn't decide to sell that to me, so I've sold that 5-acre tract separate now. They still own their HOA acreage. But I've never seen a plat or anything that shows some of that road area coming into my tract that is owned by the HOA. I see that on no deed, no plat, not on the PVA website. I don't see that anywhere. So I really don't know where they're coming from with that. But I assume, as Charlie has mentioned, the legal documents will prevail on who owns that property. As to Willowbrook Subdivision and their requirements, I have a copy of those. And when I talked to them about buying that land that surrounded my 5 acres, we were going to cut that into 1.75 acre tracts. And they would, of course, be with the HOA rules because it's a small tract of land. Now we're talking about 5-acre tracts, and they are a different animal. Most of those, I assume and envision, will have nice homes, probably small horse farms with horse buildings and horse structures or whatever they propose, but they're 5-acre mini farms is what they are. Some of the rules that the HOA requires is, and I'm just going through here picking out a few that I see as a farmer, I can see would be a problem if you owned a piece of land. One of them says, no tree shall be cut. No pets other than traditional domestic animals. The developer shall approve all construction plans. 2,500 square feet homes, brick exteriors, stained or weather-treated wood, field stone, simulated stone, or wood shingles for the exterior surfaces. I beg to differ that that would be a problem with a horse running shed, that it be built out of that. No outbuildings or sheds shall be placed on any lot except when constructed with the same materials of the main residence. All property owners are required to submit a landscape plan with written approval. No trailer, truck, commercial vehicle, motorhome, farm vehicle, or implement, or boat. And that was just a brief overview of their restrictions. I do plan on having restrictions as to no single wides, no double wides, and I think at one time I said 1650, but 1800 is agreeable to me. I'm not hard to live with, and I want to be a good neighbor. But I just feel like that the 1 acre lots that they own now are much easier maintained under these strict restrictions as my 5 acre lots would be. And the neighboring properties are do not meet their restrictions. So that's why I take issue with meeting those. Are there any questions that you guys have?
Any questions for Ms. Jones?
My question would be, in 2012, when you purchased it, was there any mention at that time of any restrictions on the property? Or?
None whatsoever. And there's nothing in the deeds or the plats that shows any agreed to restrictions.
Charlie, after you reading what has been presented, I'm assuming you've at least scanned over it. You know, there's been a lot of information given to us, but the deeds and the plats are the deeds and the plats. Do you see any restrictions or?
No, there are no restrictions that we've imposed on that property. And if we don't impose it, then a former owner has to impose it and make those like deed restrictions when they transfer the property. Since we've not done it as a final plat, the bank didn't do it and they took the property back and sold it. Ms. Jones was the next buyer. Unless she put some restrictions on it, then they have simply the same restrictions as any other 5 acre tract in the county.
And I know I may have missed, I was not here last month, so I may have missed some information. Was there anything you can find since last meeting with regards to green space, or this being a protected property under dedicated green space?
Well, it's not. I mean, the plat says this is for future development, and no future development was approved, so it never became anything. I mean, period. It's just simply like anybody who buys property and divides it into 5 acre tracts, they can do the same thing as every other one that's been done, you know, the hundreds and so through the years. Unless we have previously approved a final plat that put restrictions on it, or a prior owner had put restrictions on it.
Could Ms. Jones, and this is just a question I think I have either for us, probably for us, or maybe even Joe, could this applicant in fact change this to a cluster and put 20 homes on there instead of building 4? No.
You got 20 acres.
Well, no, I'm saying, but I think that what I think I heard is some of the neighbors, most of the neighbors have 1 acre parcels. So,
but you got to have 4 acres set aside beyond that 1 acre
for the green space. Okay, I see what you're saying. Okay, I just a thought, because I was thinking, you know, it's 4 homes versus if you throw 20 on one, you know, 20 on 1 acre lots, you'd have 20 homes, and I think that'd be more of a cluster than 4 homes being proposed, which is what I think Ms. Jones is doing.
Was that the biggest issue when you looked at continuing the cluster? I guess this is for Mrs. Jones. When you looked at continuing the cluster back, was the biggest issue trying to figure out what to do with the parent tract? I mean, with the.
If you don't mind, could you come to the microphone just so we can get it on audio? Thank you, Ms. Jones.
I don't own enough land to do a large cluster development. I only own the 22 acres.
Yeah, but I'm saying that would do 4
yeah.
smaller lots, and then
you mean should I have made a cluster development instead of the 4 or 5 acres?
Well, you would have a parent tract to go with it, but I don't know who would take the parent tract. That's
yeah. I assume
there's only one person that could take the parent tract. I assume, and
right.
That would have to be the Sharps.
Charlie, could they do that, or could Ms. Jones do that, 4 1 acre lots, and then donate the?
I was thinking we had a larger minimum.
We do. It's 1.75.
It's 1.75 now.
Right.
For a minimum cluster, I thought that was 25 acres.
I think if you're not on sewer.
Excuse
me. So it wouldn't meet the minimum requirements.
I didn't think so. Maybe we need to check that, but no, I thought 25 acres was the minimum.
I think she could potentially do it, but she would have to do 3 small lots, and then the preserve would have to be consolidated into the Sharp property, and then you'd have, so it would be very difficult to do. because you have two different owners of the preserved area.
And probably wouldn't make sense. That wasn't Ms. Jones' intentions. So just trying to make everybody happy.
I
Ms.
understand.
Jones,
Yes.
what are your intentions as far as restrictions?
No mobiles, no double wides, and 1,800 square feet minimum.
And that's your 3 restrictions?
That's all, unless you guys can come up with something that I should. Like I said, I envision these as small horse farms, small tracts of land. I don't think that the Willowbrook restrictions, not having a farm implement, how are you going to keep 5 acres mowed?
Right. This is from what I'm hearing, and I apologize for interrupting, is the people in the subdivision are not trying to stop you from what you're doing. They just want it to match what they have to improve the value of their home.
I understand that, and if you, and I know you haven't been out there, but if you go out there, I'm literally over the hill from all of their houses except that one street that backs up to that one 5-acre tract. 90% of this subdivision will never drive back there and even see this. And people coming to their homes won't know that back in the back there are 5-acre tracts. The only people that'll really see it will be the 5 or 6 houses that join it, and they're going to be joining that one 5-acre tract. The others are kind of out of sight from them. It is literally over the hill, past their subdivision.
Any other questions for Ms. Jones? Thank you. Ma'am, if you'd like to come back up, you definitely can.
I do want to disagree a little bit with what she said. Every one of those homeowners will come through our subdivision. We maintain
the people that own the 4 tracts. Yes,
and all of their
your people would not
and
be
all
back
of
there.
and all of their farm equipment and everything will come through our neighborhood. They will use our roads. And I don't think I made myself completely clear. I think you tried to address what I said a little bit, and that is that I don't expect them as a farm owner to not have animals. But, you know, we only put up 4 rail fences, even in our neighborhood, or even if a homeowner wants to put it around their property. That's the kind of restriction that we would like. And if the farm owner that puts a fence around that borders 6 of our homes in our neighborhood, our homeowners are responsible for helping to maintain that fence. My house comes up to the Bingham property, and we help maintain her fence, and we keep it because we respect that. We like farms. I mean, I don't think that, the small house is not too unreasonable. I think someone who's going to buy that 5 acres is going to pay a reasonable price for it. And I think if they put a tasteful barn, we can't limit their tractors and their trucks. Jody and David have tractors and trucks in their home, on their property, and they're under the barns. And those are the kind of things that we would like to have some sort of, so that it's not just a total lack of concern for the areas of those farms. I mean, they may have animals that are going to get out and come into our neighborhood. And those are the restrictions that we would like to have.
Thank you. Sure, come on up.
I'll be real quick. I wanted to respond. Mr. Vest said he thought we were saying that it was all good as long as the restrictions were there, and I would like to say no. My opinion is I think that it's time for P&Z to stand up for a little land preservation, and I would love to see somebody buy the 22 acres as a farm or add that to, additional property. I know Beckham and them have several farms that they farm, and so I want you to just say no. But if you can't say no, then we need to look at restrictions like Sandy said. So I just wanted to clarify. I can't speak for the whole HOA, but that's my point.
Thank you.
Oh, sorry. Yes, sir.
Oh.
Come back up here. Come back to the microphone, yes. It seems like the Willowbrook is an entity in itself.
That's why we live there.
And that your property value is because of you being part of that entity. That I not consider my home to have a certain value, and what my neighbors do is very little influence on the value of my home. Seems to me like the value of the homes in this community are what they are, and what happens across the fence or over the little hill is really not going to affect the nature of that community, and therefore not affect your homeowners, your value. So I'm confused about that.
Well, I guess it depends on who moves in. I mean, if somebody slaps up chain link fence and puts out 9 outbuildings and has a goat ranch, I don't really want them living down my street. And you know, somebody else may think that's just great, but I didn't buy with that. You know, we have cows. Beckham's cows come to visit me sometimes. They haven't jumped in the pool yet. That's okay. I am not anti-agriculture. I grew up with it. I would like to see the Planning and Zoning Committee deny this because it's land that can be used for agriculture. We keep chopping this county up, and what's going to be left? So that's my ultimate concern, and obviously my property value, because it's the most expensive asset I have.
You haven't said why you think your property value will go down as long as you're part of this community.
Well, I don't know. We don't know who's going to buy it and what they're going to do. And with all due respect, I have trouble always believing what Mrs. Sharp says, because we've heard a lot of things through the years. And so I don't know that I can take her at her word, to be quite honest.
Mrs. Sharp or Mrs.
Jones? I'm sorry, Miss Jones. Miss Jones. Sorry. At one point, there was a last name change. Okay.
Thank you. Any other questions? Ms. Jones, you have anything else to say?
I'd just like to say I don't know that I've ever met this lady or ever talked with her. I never talked with anybody face-to-face in that subdivision. I did make 3 or 4 phone calls saying, would you be interested in selling the HOA space? And it was just a few short years when all of these homes was a farm also. So they're living the dream, and they're not wanting anyone else to live the dream, obviously. But the land is there. It's 22 acres. It's currently on the market for sale as a whole. So if the HOA is so interested in staying a farm, possibly they should get together and buy it.
Thank you, Ms. Jones. If there's nothing else, discussion, thoughts, and a vote.
Either way I vote, I'm going to violate some of my principles. Difficult.
I'm leaving it up to you. Or somebody on this commission. I need something, a vote, a motion.
I can give you my thoughts.
We'll take that too, Stephen.
I know that I'm sure that John Sharp had his intentions were probably to continue this cluster development, and that probably would have been a great thing because without continuing it, there's no buffer right there. You didn't have without having a contiguous farm surrounding you, which you did not. You don't have the guarantee of a parent tract to ensure that more 5-acre tracts couldn't be brought off of that. That parent tract would have only had 1 building credit on it, and you wouldn't have the ability to further divide it. But as it is, in 2012, when this happened, no restrictions on the deed. We can't change the law. That's basically the only thing that we could do at this point. What you're asking for is that we go to the same thing as Woodford or Fayette County. If we're going to go to 30 or 40 acre tracts, then it's a pretty big decision, especially for this group. And a lot of people really aren't that much in favor of that, because that pretty much limits the number of people that can ever live in the county. When you go to 40 acres, then you better have some deep pockets to go living outside the city.
Thank you, Mr. Smith. Any other comments? I need a motion.
Here's what I think. Ms. Jones bought this piece of property. She has the right to develop the land. I think we all agree with that. I agree with the homeowners association. They don't want all that in front of them. So we're kind of we're stuck in the middle here. We only have to do, or only can do, what we're permitting. Is that correct, Charlie?
Yes, sir.
And there's no stipulations. I mean, there's really nothing in the books that can deny Mr. Jones this.
No, she has the same rights as every other 5-acre subdivision
If I
that
bought
we've
the
done.
22 acres, it would be the same situation.
If you bought the next 22, it'd be the same thing. If you bought them on Muddy Ford Road or something, it'd be the same thing. We have very few rules where it comes to 5-acre tracts, and as staff reported, they meet them.
I'm not necessarily saying that I agree with that, but I understand.
Well, if this is a 20-acre tract that's sold, one house could be built on it. If we divide it up, that's 4 houses. Of course, as most of you know, I'm usually take the position of let's keep as few houses and as few people in Scott County as possible. And by not dividing it, we are moving in that direction by getting rid of 3 possible more houses that could be here. That was terrible grammar, but you know what I mean.
I think I'm going to make a motion.
Okay, motion.
I think I'm actually going to make a motion for approval, and I'm going to make it with, can I make it with the stipulations that she listed for her restrictions on the no mobile homes, no?
You know, we can't require her to do that. I would probably say we would certainly appreciate, Rita, you stipulating that on the record that that is what you're going to do, but I have serious doubt that we could sue you and enforce that. But that'd be the best we could do. She stipulates that on the record, and then
Based on the
obviously follow that
stipulations
through.
that she stated,
1,800 square foot minimum.
with 1,800 square foot minimum, and can we request, not require, but request that she put up the wooden fence, the wooden 4-plank fences?
Currently, the fence up against this subdivision is a woven wire fence. That's what's there currently. Between my property and the subdivision, backing up to all their houses.
Okay,
is a woven wire
On the
fence.
Willowbrook Lane side, everything on the Ashland side is plain.
Okay, we have a nodding of agreement from Mrs.
I think the other mention was no mobile homes.
Yeah, no
She said
mobile
that.
homes,
Right,
but,
I agree with that.
okay. We have agreement from Mrs. Jones and the 7 conditions of approval. Do I have a second?
Any second?
No. Oh, come on.
I don't think we have much choice but to approve it. It's just unfortunate that
We always
something
have a
didn't happen in the
choice.
past. I mean, it's a very nice development. If it had been, if that section had been finished the same way that as all of your other houses, I think you'd have a development that was complete. Unfortunately, it was not completed. I think your only options at this point are look at purchasing those 5-acre tracts as they.
So are you
So you can
making a
control it.
motion,
I
Steve?
would second. I'll second that it's.
So we've
I don't
got a
think we're-
second by Mr. Smith. I guess I'll do a roll call.
That's up to
My
the chair.
option. It's my option. So let's do a roll call. We've got a motion by Mrs. Mizell and a second made by Mr. Smith. I'll do a roll call and start with Mr. Wiseman.
No.
Okay. Mr. Moran?
Yes.
Mr. Vest?
No.
Mr. Stone?
I don't think we're ready. No.
Mr. Smith?
Yes.
Mrs. Mizell?
Yes.
And the chair votes yes. So it's 4-3 to approve. Ms. Jones, you can go see Mr. Perkins. Thank you all for coming. Appreciate your time. Next on the...
Who's this?
Wait, hold on, I'm sorry.
Byron, did you say no?
Byron,
Said
did you,
no,
I
didn't
thought
you?
you said yes. He said
Oh, you
yes.
did say yes.
You scared me. I thought I was the Miss Universe pageant again. It was fine. I got it right. I thought I had it wrong. Nothing wrong.
A second and 4 and 3.
They'll go. Oh, yeah.
Moving on, we'll go to the Duncan property, FSP 2019-32, final subdivision plat to subdivide a 5-acre lot from a parent tract of 161.6 acres located at 1279 Burton Pike. Thanks, man.
Yeah, thank you. As you mentioned, the application before you is to subdivide one 5-acre tract from a parent tract of a little over 161 acres. The property is located on Burton Pike, and it's sort of between Burton Pike and Mallard Point. The current zoning on the property is a combination of R1A, which is a single-family zoning district, and A1. The surrounding zones are zoned similarly, or the surrounding properties rather. The access to the lot that the applicant is proposing, as well as the access that the remainder would have, would both be off of Burton Pike. I've outlined in blue here roughly the 161 acre property. This is Burton Pike down here. This is Mallard Point back here. You can see Drake Lane kind of winding its way. This is a 5-acre tract that the applicant subdivided off with a minor plat, I believe, last year. The approximate location of the 5-acre tract they're looking for approval on tonight is roughly in this location here. This is the zoning of the property. It's I didn't include the entire property. I kind of cut it off for the sake of being able to actually see some things. But this is, just to reiterate, this is the area that we're looking at. So the 5-acre tract that they're proposing to create would likely have 2 different zoning designations, and I can touch on that more here in a second. Going through the staff report, the part of this property that is zoned R1A is sort of a leftover part from when Mallard Point was rezoned, or property was rezoned for Mallard Point. This area was proposed at least at one time on a concept plan to be a part of Mallard Point. That development never quite came out this far, and the property was sold, I believe, at auction around 2016. The access points, as I mentioned, both access points for the remainder, which already exists, will be off of Burton Pike. The proposed access, the applicant has indicated on the preliminary plat that you have a copy of, they've indicated that they've already had discussions with the Kentucky Transportation Cabinet, and that their proposed entrance seems to be agreeable to the cabinet. The only, I wouldn't even call it an issue as far as the zoning ordinance is concerned with this application, deals with the setbacks. It's not very common that we have a property that has 2 different zoning designations on it. And so it could be a little bit tricky as far as when somebody goes to build a house or things like that. on this property if the plat, sort of the setback lines essentially shift back and forth. So the A1 zoning district has more restrictive setbacks. The setbacks are 50 feet from all property lines, whereas the R1A district has 40-foot front yard, 12-foot side yard, and 25-foot rear yard setbacks. And when the applicant draws up the final plat, should you approve it, when they draw up the final plat that gets recorded, they could show the setback changing with the zoning district. I think it might be easier or cleaner if the applicant sort of voluntarily agrees to establish 50-foot setbacks for the entire property. It makes sense to me because those are setbacks that we typically see for lots of this size. It's the setbacks that they have, I believe, on the adjoining property, the adjoining 5-acre tract that was created. Obviously, the applicant isn't required to do so, so it's merely a suggestion. I am recommending approval of their application. Sorry, before I get to that, this is a copy of the drawing that you all have in your staff packets, but shows the proposed 5-acre lot. As at this time, they're showing it with the R1A zoning setbacks. I believe they had the proposed entrance labeled here. I kind of cut it off so that you could see the tracks that they're proposing a little bit better. But I am recommending approval of their application. I found it to be in compliance with the zoning ordinance and subdivision regulations, and I guess I'm recommending these 4 conditions that are listed here on the PowerPoint and in the staff report.
Any questions for Matt? Thank you, Matt.
Thank you.
Is the applicant here to speak? Is the Thoroughbred Engineering? Is Keith here? Oh, yeah, Keith, you're here.
And the owners are here.
Oh, okay. Do you want?
Well, if it needs to be addressed, we'll be happy to address it.
Well, Keith, you want to come up and at least answer? Does anybody have any questions for the applicant? No. Okay. Oh, come on. Somebody here wants to speak?
We're not opposing of the 5-acre tract. We're just worried about the down. We live below him.
Okay.
And I have
well, come on up and state your name, just for the record, so we have it on recording.
Melinda Jones, 1622 Burton Pike. Burton Pike is booming, apparently. Everybody wants to live down there. We've had about 15 houses above us to go up in a matter of a year and a half per se. And we have a little stream that runs in front of our homes. And now, my mother's lived there for 65 years. We've got water when it rains up to our waistline at her door, almost over top the hot tub. And the problem that we're seeing is there's no storm drainage. When they put up 5-acre lots, y'all don't require a storm drainage plan. It's all coming down on us. And I had pictures with just a small rain driving on Burton Pike. It's flooded. We've had to have the sheriffs come down. There's 15 to 20 cars in my mother's lot because they can't get on down the road. We've never had to deal with water like this. And I'm not opposed to the 5 acres. What I'm opposed of is all these houses going up and nobody taking care of the drainage issue. We're receiving it all. We've lost equipment, farmers have, and it's out of control. If you're all gonna zone this, that's fine. They need to have a drainage plan.
Thank you. Ben, do you want to address that at all? Just, because I have had a couple people call me, not about this application. Oh, I've seen pictures from other people.
This is what we live through. It gets up in our homes, and then it's flooded the roads. You can't get past,
right.
And you are allowing this to happen.
It's a stream. It is in the county. 5-acre tracts are ag lots, and to put a house on there, it is not the development, so it does not fall under the. Otherwise, we'd be making farmers build
Right.
detention basins before they.
And I've
plow
had
the
a couple
fields.
people call me about Burton Pike because I guess it does flood.
Burton is not-
I told them to reach out to Ben, but what do we do when we have county roads like that flood?
You're sitting with shivers down and putting up these little things close to the
No, but
road.
I'm saying how do we rectify it? I guess not.
With the
Signs
drainage
don't.
plan, the storm drainage.
Ben, who handles that? Who would handle it?
The county has multiple roads that flood regularly. It happens all over.
Because the planning and
It's-
zoning, it's not our job to make sure a road doesn't flood, but definitely when a development's being put in, we ask that the
Right.
proper drain go in. But Mr. Wallace is here, who's a magistrate, and he said it's the state's responsibility to.
It is.
Yeah, it
That's
is.
the state's responsibility.
Yeah. So there's your answer. Got called state.
But that's not gonna keep the water from coming up in your.
No, but maybe.
Well, I
they can-
understand
in
that.
your
but
yard.
What you don't understand is we did not have this problem until all these homes started going up.
But we
On
never
these
had,
5 acre tracts.
we never had rains like we've had in the last 4, 5, 6 years either.
Yeah, we have had some record rains.
Absolutely, last
Well, I
5, 6
agree with
years.
that, but it's still, I mean, when it's just a shower, you expect the runoff to be able to go into the creek. It's not we can't even hardly hold just a normal shower anymore.
I mean, I definitely would recommend reaching out to the state and expressing your thoughts, and maybe they'd come out there and do a study. Problem is with planning and zoning, for a 1 5-acre tract to be broke off 161, is that causing it? Maybe, maybe not. But the state would have to look at the drainage out there. They would also have to look at the roads, and then they'd probably address some of the creeks. Yeah.
I mean, we had a neighbor that just built a home, and they didn't ditch. So everything comes down. You had the fire truck department out there spraying it off.
I've also heard there's supposedly some man-made dams or something in that creek as well. I've had somebody call me once, said some people had built up some rock stuff, and again, I didn't go out there because we have no say-so planning
I mean,
and
I'm
zoning.
not wanting them to stop their 5 acre lot by no means.
Right.
My main concern is that we don't continue to have the flood issues and us dealing with it.
I appreciate it. There's not much we could do, but
State.
thank you, Ben. Thank you, Ms. Jones.
We've had
Definitely.
We've had
Yes, we have.
very odd rains in the last.
Anybody else have
2 or 3
any
years.
questions, thoughts, comments? Crowd? Anybody else in the crowd? Mr. and Mrs. Walls back there.
I really don't know what's required.
Come on up here if you want to speak. We're gonna bring you up to the microphone. We're gonna embarrass you.
I know it is. It's like,
So state your name.
I'm Tabor Walls, and we're the applicants, I guess, for this. Like I said, I don't know what the requirements are. I have no idea how things were, ever have been for you all. I know that our builder is talking about digging the culverts, putting all the stuff in down at the bottom of our land so the water runs off certain ways and all that good stuff. I've never built a home. I've never built a shed. I've never built a doghouse. So I don't know what is required for anything. But we're not going to try to flood you. We'll be good neighbors.
Well, I'm just saying that, when you get 20 new homes and everybody's pushing dirt, the water has to go somewhere.
Right.
And it's all coming down on our end. Take a little drive in the afternoon when it's rained hard. You can't get past my mom's house.
And again, with them having 5 acres, right, is yours?
Yeah.
We'll hold them to the standards. But as far as the overall road and the other 156 acres left, that's something you want to address with the state.
And then my next question is he planning on developing? Because
There is
I
no
don't
standard
know,
in this.
Mr. Duncan.
I'm
just saying, I don't know Mr. Duncan, and we had heard that he originally wasn't going to develop, and it's a concern.
Right.
We're having
Well,
this-
if he goes and develops anything more than this 5 acres that he's partitioned off the 161, he'll have to come back to us. So he won't do anything without having to come back to us. Okay.
But when does it turn into a subdivision? I guess that's my question.
I think you're right.
Can he give 5 acres to his son or his daughter and his grandchildren?
Is
and
it
then-
4, Charlie? True?
Is it 4 or 3?
More than 3. So on the 4th one, then it would be considered a true subdivision. Thank you.
I guess that was my main concern.
All right, appreciate it. Thank you. Any other questions? We need a vote. Motion.
I move we accept this application.
All right, so I've got a motion by Mr. Wiseman.
A second.
A second by Mr. Stone. He beat you. So all in favor say aye.
Aye.
Okay, opposed, so carries unanimously. Go ahead and Keith sign with Mr. Perkins. Next on the agenda is Bluegrass Regional Land Use Resolution.
Yes, this is a proposal to, and Claude, I promised Claude we'd get this done by 7:30 because he had a conference call at 7:30 and it's exactly 7:30.
We promised family too, didn't we, Mr. Chairman?
Yeah, my wife went and picked up the kid.
Yeah.
Okay.
So this is a resolution, a planning commission resolution. Y'all ready?
Yeah.
Let me wait a second.
They gotta go outside and talk.
Oh, would y'all, if you want to move, you could take conversation outside. Have a good night.
All right, ready? Do you all have something that? Okay. Okay.
If you want to speak, you can always come up to the lectern and talk if you want.
This is date night for us. We don't live.
We're honored.
Yes, you were blessed with your presence.
All right. This is a resolution proposed for the Planning Commission to vote on and accept endorsement of a Bluegrass Tomorrow resolution that was put in your packet. This is a regional land use cooperation resolution that's come out of Bluegrass Tomorrow. It's been a process that they've been going through, looking at how we can better cooperate in planning, land use planning, but also just general cooperation among planning units and those in the planning profession in order to further cooperation amongst the varying groups and planning commissions in the Bluegrass region, which is the 18 counties surrounding Lexington. And Claude is here to answer any questions on the specifics of the Bluegrass Tomorrow resolution. But there are 17 principles, kind of guiding principles. Most of these are principles that are in local comprehensive plans for the different planning units in the region. All of them are, in compliance with our goals and objectives in our comp plan. There's nothing that's not doesn't follow what we've already listed as goals and objectives in our comp plan. I see this as a kind of a starting point in communicating amongst the different counties on how we plan, communicating on our comprehensive plans, how they can be better coordinated, and moving forward. Bluegrass Tomorrow is a nonprofit group that is interested in smart growth and good planning. They just want to promote that, and they're taking they've developed these principles and they're taking them around to all the counties in the region and trying to get endorsement from planning agencies in the region and legislative bodies in the region to kind of sign on to these principles. Claude is here to answer any questions on that, but I don't see any issues with us signing on to this. I think it's a good thing. I think we need to cooperate and coordinate in the planning realm. Mark, you've asked me to reach out to fiscal court, and I sat down with the judge executive and I gave this to him and talked to him about it, and he sent it out to all the fiscal court members, and I haven't gotten any negative feedback or comments from any of them, so they got it yesterday.
How about city council?
I didn't send it out to city council.
How come?
Well, I didn't think I'd have time to hit everybody. You asked
that was
about
Monday.
fiscal court.
You could have crawled to city council from planning and zoning office.
Well,
Come on, Mark, leave them in peace.
If you,
I'm not. I'm
if
picking
you want
on
me
Joe.
to
You're
hit
usually
city
pick on
council,
Joe.
you mentioned fiscal court.
I said both city council and fiscal court.
did
I
you?
wanted to get
Well,
the. Yes,
it's
I
my
did.
fault
Charlie's
then.
nodding. Yes, I did.
Did he?
Yes, I did.
Okay, I'm sorry, I missed that.
You and I were talking at the time. That's
so he wasn't paying attention
Yeah,
to
I
what you're saying,
apologize.
Charlie.
I don't really, there's nothing binding in this. If you see a reason to postpone it another month, I can go talk to all the city council members as well. So
My thoughts, and again, I'm not opposed to it, but we do have Charlie ordinances, and we have a comprehensive plan that does dictate rules and regulations for growth and land use and other things within our county. So that would trump anything.
Absolutely.
I mean,
Yeah.
question I had is, as I looked at the board members, there's a lot of Danville representation. Is the 13 counties that includes Danville? I guess if you're looking at me, Danville would be over here, I guess, or no, vice versa, Danville here and Berea over there. But is that 13 counties are they all joining, or is there?
touch.
They do
Yeah.
touch. I was wondering because I thought Danville sure does seem a long ways away, but they do in fact all touch. Okay, but they all do in fact touch.
17 or 18.
Because I always look at the Bluegrass being 9 acres, and I'm sure Mr. Crisp would verify 9 acres is Bluegrass, right?
9 counties.
9 counties, That's what I meant. The counties, not acres. Thank you. And so when we had 13, it kind of stretched a little more, a couple more.
yeah, it's the outer ring,
18.
inner
Sorry,
and outer
18.
ring of counties.
So 18 instead of 9. So you kind of really broadened the Bluegrass area a little bit.
I think
It's an operating area. It's not.
I'm just trying to grasp it because to me, we've really only heard and talked about this for, I guess, 2-3 months. Yet I see that, like even in the Bluegrass agreement, it says that this regional land use partnership's kind of been talking since November of 2017. Yet it's really just been brought to us here just in the last couple months.
Well, they have been. I mean, I've informed you of it in the past of this group meeting, but you probably don't remember.
That's probably all. Yeah, you said is this group's meeting. There's a lot of groups that meet.
Yeah. I mean, it's there's members, there are representatives from Scott County. I mean, it's not a huge group. It's a land use interest group.
Yeah, the board's 50 strong. Would you say?
52, the board passed it in December. We signed it in February.
Megan, yeah, she was on the Bluegrass side.
I think the important
The time gap had to do with us vetting it. We vetted it through all the people we could think of, all the potential stakeholders. Everybody had a chance to look at it, and we had a lot of feedback, and we made corrections or changes, if you will, based on that feedback. So what we've got here is pretty much common ground, which is what we wanted out of this first step. Let's find the common ground and build on that.
Right. As I think I've said in Monday's meeting, I've been in this area 9 years, and for 9 years I've heard that we never wanted a region. We didn't want anything to be regionalized here out of Scott County. And so to hear this and really not get any feedback from City Council, as I asked, and apologize that you didn't hear me, and very minimal feedback from any of the magistrates. I did talk to one, and I'll leave him because there is only a gentleman on fiscal court unnamed right now because I don't want to speak for anybody. That person didn't feel like he was in favor of this, but that's just one person. So I really want some more feedback from some of our politicians, and maybe I need to reach out to some people in the community. I don't know if I can ask the commissioners to do the same and maybe get a little more feedback, because again, what I've always heard is we did not want to partake in regionalization of anything because we didn't want to become the next Kentucky. We wanted to be Scott County. Or we didn't want to be the next Lexington. I'm sorry if I said Kentucky. We didn't want to be the next Lexington. And I know we're always compared, Lexington does this or Lexington does that. And to me, I think this may be the first step. I don't know.
I think the big part of this is it's not that they're trying to take over what you do here locally. I think there's some projects that are bigger than Scott County where you need to be involved with your adjoining neighbors, and you need to work together to come up with transportation plans. If we ever want to get a trails plan together, finish the legacy trail, I'm sure that can be accomplished much easier if you're working from a regional outlook instead of local.
I think the coordination, the cooperation, the communication is important. I don't think anybody would disagree with that. I don't think anybody at Scott County government
I would
doesn't
definitely
want to
say some of our
communicate
government entities play well together with others. And then sometimes we disagree with other counties, one in specific being Fayette County. One of the things I'd read on here that, again, it does interest me. I'm not against it. I'm not for it. The intra-regional connectivity planning for multimodal transportation. You know, would there ever be a Lexus Tran in Georgetown? Well, no, probably not. But, you know, I don't know if I could see them having Lex Tran going in other counties outside Fayette. What?
We have G-Tran, and G-Tran
which is separate.
G-Tran runs between Georgetown and Lexington.
Does it go to Lexington?
Yes.
I did not know it went outside of Scott County.
We have one. Don't we have one that goes between?
I'm not sure if it is now.
Regina, I honestly, that's first I've heard of it.
I believe we have a route that goes.
It was in the plans, but I don't know if they're doing it yet.
Okay.
But.
So there's a lot of unknowns for me personally.
So did you say it's a 50-member board?
52.
I think the Bluegrass Tomorrow board is 50 members. Yeah.
Claude just said 52.
52.
If you'd have been listening.
How many of those appointments are from Scott County?
It's about 4 or 5.
I think
5, I think, right now.
Yeah.
Okay.
I'm the chairman, so you got that. For what it's worth.
So you said there were 17?
18 counties.
18 counties, but there were 17 items that were...
Seven.
Okay.
7 principles.
7 principles.
Which is on here.
So this is not restrictive. It can actually incorporate some other things like future endeavors such as Green New Deal. For an example, if counties wanted to go green, and it wouldn't limit or be restrictive to cancel out one county from this being a part of this 18 county collaboration with it.
I don't know if I followed that. But these are the fundamental principles that they're building off of.
Yeah.
I think it can develop, you know, if it meets, if it goes further. Maybe I'll let Claude answer this since I wasn't actually involved in developing all these. But these are the fundamental principles guiding the group. So I don't think it'd veer off into areas outside of land use, kind of cooperation, communication. I think it'd be focused on that. But
Mr. Christensen, would you like to speak? Sorry that you missed your conference call too, by the way.
So am I. Claude Christensen, 118 Eagle Bend Drive, Sadieville. What are your questions?
Question?
Does it cost anything for each county?
No money is involved.
No money is involved? Okay.
This is an agreement in principle. The purpose of it is to hopefully encourage and create better communication between the planning entities in the 18 county area. Bluegrass Tomorrow is really in the business of quality of life. We try to bring organizations and people and stakeholders together that have some common ground and make good things happen for the area. And that's what this is about. This is a kind of a baby step. It doesn't affect at all any organization or governmental entity sovereignty. You can adopt it and disagree with stuff moving forward if that's what you're of a mind to do. You can adopt it and support stuff. The idea is, here's a set of principles. We think that they're good principles, and based on the vetting that we did with this before we went public with it, a lot of people think that they're good principles. They make sense, they're kind of no-brainers, if you will. And the idea was, okay, let's find a place to start so that we have, okay, when we plan in Scott County, we kind of try to invoke these principles. When Fayette plans, they try to invoke these principles. They may or may not, we may or may not. It doesn't preclude Scott County from doing what Scott County needs to do moving forward. You know, so it's an agreement in principle. It's not binding in the sense that that going to break any laws or anything. And as Joe said, it's compliant with all the regulations, and we wrote it specifically and intentionally that way, so that we knew that we didn't want to politicize it. We didn't want any of that kind of action. What we want to do is get people communicating, and here's a starting point with these principles for planning around land use.
Well, that's my question. gonna vote on it tonight?
Well, it's up to us. We can vote on it tonight. We can just listen to it and not say anything. It's really up to...
Mayor Prather has seen it. He was on the board. He is on the board. And the board, as I said, approved it in the final meeting of 2018.
So probably December-ish?
Yeah, we would have met in early December. And they had it before that, so they could look at it. We vetted it with everybody we could think to vet it with. Planning Commission, Bluegrass Ad, all those folks that do this sort of thing have been contacted and have seen it and have weighed in on it. And we went through several iterations before we kind of landed on a place where everybody said, yeah, that's a pretty good starting point.
Sounds good to me.
Number 7 here talks about the RLUP. Is that a separate
Regional Land
organization?
Use Planning
Partnership
Committee, for
Is
lack
that
of
a
a better
separate
word.
organization, or is it?
No, it's a subgroup. That's a
Subgroup of
specialized
this
group in Bluegrass Tomorrow that basically did the work.
And it stands for Regional Land Use Partnership.
Right. We like the word partnership. It's harmless, trust me. I wish it had more teeth, but that's just me.
Do you think Joe or Claude, or I'll even ask legal counsel, seeing
Oh
that
my
he's here
God.
tonight,
We're in trouble
that this
now.
could be possibly more, to get a little more public feedback instead of just bringing it to planning and zoning and saying, hey, vote on this? Do we need to?
Well, let me just say, Lexington City Council passed it 2 weeks ago. Midway's passed it. Bourbon County Fiscal Court passed it, or adopted it, if you will. So it's got some fans out there. I had hoped Scott County would be out front. We kind of missed that boat, but I would really recommend you consider it seriously, because it's going to give us the same starting point that it gives Lexington Fayette. We have the same set of principles then that we can invoke as they would be required to invoke or encouraged to invoke as they do their planning. When we have borders, and you've got an imaginary line and you've got one zoning on that one side of the line and somebody else has a different kind of zoning, that can create problems for both groups, and we're just trying to avoid some of that. And if we communicate based on common principles, we think that'll help.
Or to Commissioner Smith's point earlier is, do we want to maintain our identity as Scott County and continue with 5-acre lots, or do we want to go to 40-acre lots and slow down
It's a separate
development?
question. You can do that or not do that under this agreement.
Right.
That's what we did. We didn't want to get into that sort of restriction one way or another. Now, maybe it'll make sense. Maybe as a region, we would find our way to what the right number is for that sort of.
Right.
But let's find our way there based on common principles.
But I mean, I think it's pretty clear today anyways, Scott County has one mindset, 5-acre lots, and
Yeah.
Fayette County has 40-acre lot mindset.
Bluegrass Tomorrow has no opinion one way or another about
Right.
that. We're trying to get people to talk to one another.
We're supposed to do that without this, Claude.
Yeah. See how well that's worked?
Yeah, exactly.
Are we not now talking to each other? I mean, is that the point, that we're not now? And we should?
Not as much as we could in terms of this commission or that planning board or the people that do all of this down in Lexington or other places. They go about their business, they have their comprehensive plans, and they're going to take good care of their constituencies, which is fine. We're just trying to say, okay, here's a good starting point. When you do your plans, consider this. Work these areas in there. Talk about transportation networks. Talk about land preservation. Talk about saving and preserving the good agricultural land.
Did you use a blueprint from any other part of the state in order to come up with this?
No, we looked around. We actually looked outside of the state too. We went. Yeah. We had some other sources, and we did some research and did some reading and did a lot of talking. And so this is, I don't know that there's any new idea here. It just seemed like when we put this together that these things make sense, and everybody. What you see is what's been agreed to by all of the people that have seen it, and there are a number in the hundreds of a diverse community of professional planners and elected officials and business stakeholders, people that favor development, people that favor agriculture.
So how is that information shared? And how will that information be shared with each plan?
Bluegrass Ad, and Joe, if you'll help me on keeping the terminology right, Bluegrass Ad has basically a regional planning committee that they host and sponsor. They meet quarterly?
Every other month.
Every other month.
Yeah.
And we're going to be back with them, and they've seen this thing too. We'll be back with them in another month or so to talk about where we are with it. We've presented a couple of different times to them, but those are basically the professional planners, I guess, and some elected officials.
Planners, planning commissioners.
So that would be a primary, if not other vehicles too. But and then planning commissions talk to one another. Professional planners have their associations, particularly that are closely held here in the area. So there's a lot of channels out there, and we just are saying use them.
So how is it shared with each operating entity like this? I mean, what comes
It'll
out?
likely be shared through these groups, through the regional planning group at the Bluegrass Ad, which is all 17 counties. This is an additional 18th county into the Bluegrass Tomorrow group, but shared through that regional planning commission and their other entities, and then through APA, American Planning Association.
There is
Kentucky.
a habit that's being formed, I'll call it a habit, that the regional or the counties are basically learning to share their comp plans with each other. And we have somebody that collected all of those for Bluegrass Tomorrow, everything that was in existence at that point. So we kind of had a compendium of everybody's comp plan. So that's another channel.
So when we meet after, when this board meets after Bluegrass Ag meets, and you guys will be at those meetings, will that information be shared with the commissioners locally?
Yeah, actually, you all are invited to all the Bluegrass Ad Regional Planning Commission meetings. If you all would like to go, we can let you know when they are every other month.
Okay.
I think the push now, or the focus now, is to get this out and adopted by as many of the counties as possible.
So if they've been meeting since November 2017, how come we've never been invited before?
Well, we're talking about the Regional Planning Council. Meets every other month. This group was a working group within Bluegrass Tomorrow, meeting on this language, kind of weeding through and coming up with consensus on the language of these principles. There was a conference, or a kind of a day-long workshop in November 2017.
Conversations on land use, yeah.
So I think you were all invited back then.
And there'll be another one of those this fall, by the way.
So
make sure we get an invitation. I'll go, assuming I can.
And they don't have at this point, they don't have a directive as far as, they're just trying to get started, and there are probably only certain things that need to be looked at.
Well, I think they do have ideas and thoughts of what they want to do moving forward, and I just don't know if we really truly. I don't feel like I have my arms around exactly what you're looking to accomplish. I mean, the language looks nice and it sounds great, but I'm kind of interested in long-term and short-term goals of this organization.
I think the biggest thing is just cooperation and sharing
Should be doing
information.
that today.
It's hard to. It's a whole lot easier to do it if you intentionally come together to have it done.
Any other discussions, comments, questions?
What staff think?
I think it's a good thing.
What about these two? That's who I'm pointing at.
I don't have any problem with it. As we've kind of discussed before, sorry, my nose is a little bit congested, but as planners, in the region and statewide, we communicate pretty regularly when we have questions about, different ideas, or, how does your community handle X or Y? I go to the Bluegrass Ad Regional Planning Committee meetings just about every time that they meet over the past year and a half. I mean, they're good groups. The communication is very good and important. And so I support.
Joe, have we been as a commission invited to those meetings in the past?
Well, there's an appointed representative from staff.
Okay, that goes, so-
But it's HB 55 hours too.
Okay.
So, I mean, more than one of us go, but you're welcome to go. You've been.
Yeah, I just don't ever remember being invited to these meetings, and I've been on this commission 5 years now, 4 years maybe, 4.5, believe it or not.
We'll start sending out the notice. We sent out the notices for years to everybody, but nobody ever went, so we kind of periodically we tell you about it, but we can
I'll make my
start
short
sending them out.
opinion or statement, and if y'all want to vote on it, you can. I really love and enjoying living in Scott County. Proud of our identity, as I think this gentleman here is very proud of our identity. As we continue to grow, I hope that we don't lose our identity as Scott County. And I hope under the leadership of the current commission, the boards, and the politicians, I think we need to keep our identity. Now, I'm not necessarily opposed to this, but I don't want to give up Scott County's identity because I'm really proud to.
I don't see where you will be.
I just worry about that, Claude.
I wouldn't have said that in the paperwork.
I just know when I'm out and about in Kentucky, I'm proud to say I'm from Scott County.
Understood. So do I. That's why I want Scott County out in front of this thing.
Do we need to vote? We can do whatever we want, but
I would move that we go on and adopt this. I don't see anything here that.
So we can
the
do
following principles is a common ground
vote and
starting point.
So I've got a motion by Mr. Smith to adopt let me read the exact.
Bluegrass Regional Land Use
Actually,
Resolution.
since we're not the ultimate authority here, I would suggest making that a motion to approve it.
That's right.
It's the
Motion to
governing
approve.
bodies.
Yeah,
who would
then
ultimately
it
adopt
probably needs to go to the.
We'll make the rounds with the legislative bodies.
But I would say our motion would be to approve it.
We would be a starting point, and then it needs to go to the.
We just thought
fiscal
talking to
court
you
and
first
city
would be
council.
better than going to the cities.
And I second that.
So I've got a motion by Mr. Smith and a second by Mr. Moran, and I am going to do a roll call just to approve or make a motion to approve the Bluegrass Regional Land Use Resolution. So I'll go roll call, and I'm gonna go in different order. Mrs. Mizell.
Who are you?
I'm sorry.
Yes.
Yes. And hang on a second. Yes. Mr. Smith.
Yes.
Mr. Stone.
Yes.
Mr. Vest.
Yes.
Mr. Moran.
Yes.
Mr. Wiseman.
Yes.
I'm gonna say no. Just to be difficult.
You're outnumbered.
And I'm okay. I'm outnumbered. I'm okay with that. Thank you, Mr.
We forgive you for your.
We know you're different.
I am different. Thank you, Mr.
Thank
Christensen.
you. We appreciate
and I
the
appreciate
time
you
you
staying late for us.
Yeah, it's okay.
We have, I don't think anything else on, upgrade a previous approved project.
It's time for your.
Yeah, here we go. We'll make a
There we
motion
go.
to.
Now we're talking. Thank you,
And I look forward to my gavel next month. Thank you.
You know what I use in Sadieville? Crab hammer.
Well, I asked him to give me a gavel, and I almost ordered it myself.